When we left off yesterday, we had been talking about block grants, which is, of course, another way that the federal government distributes money to state and local governments. This is part of our broader discussion of intergovernmental relations and related in some ways to grants, but also a problem on its own is the problem of mandates. And mandates, of course, are things that you have to do. If it's mandatory, it's required, and federal policies may require state implementation, which in turn means state spending. Anything that the government is going to implement will have some expense, and a lot of these are unfunded mandates, which are mandates that come without federal spending to help. For example, spending to make sure that state buildings are in compliance with the Americans with Disabilities Act, which can require pretty serious retrofitting to older buildings, for example. And as I said, these are known as unfunded mandates because the government requires that something be done without providing the money to help carry out that implementation. And as I said, sometimes this can be connected to grants from the federal government. And so, of course, what we need to know is that even when the federal government is providing funding, the funding may not cover all of the costs of a particular policy. And an example we've already talked about previously is Medicaid. Medicaid has cost sharing between the state and federal governments. In order to continue to offer Medicaid, states have to share some of that burden. Another example, No Child Left Behind. If you're not sure that you will remember that abbreviation, I would encourage you at least this once to write that out alongside the abbreviation. No Child Left Behind was a George W. Bush administration policy to try to raise educational standards and raise educational outcomes on a national level, with a lot of organization from the federal government, but implementation and costs borne by the states. And they had to comply to continue to get federal money. And these problems remain true even when federal money covers most of the costs of a program. And the reason for this is that states still spend money they might not have otherwise spent in the absence of the federal program. And as a result, state and local governments that do not have the money to bear their share of the costs may turn down any participation in the federal program in order to avoid the mandates. And that's kind of what's captured in this political cartoon. Right? We have schools trying to comply with No Child Left Behind, and it's an unfunded mandate in the sense that half of the money is not provided by the federal government. And of course, this is just a political cartoon, but it does get the message across, as does this. Right? The man in the desert struggling and shackled to a ball and chain that is the mandates from the federal government. It's kind of an analogy to help understand this. Imagine that you have an affluent friend who invites you to go on a vacation, a really nice resort. They're going to pay for the room. They're going to pay for all of the expenses at the resort, but you have to cover your airfare to get there. And you simply do not have the money to afford the airfare to go on this wonderful vacation that your friend is otherwise going to pay for. And so you turn down this amazing vacation because the airfare is too expensive. That can be the same thing that states face, right? Giving up something they would like because they cannot afford to share their part of the funding requirements. As we think about these things, we're mostly thinking about mandates that originate in Congress, such as the Americans with Disabilities Act, but not all mandates originate in Congress. Some of them come from court rulings in the federal courts. As an example here, might have a federal requirement that in order to provide adequate conditions for incarcerated Americans, that states build new and larger prisons, which is a real issue. America incarcerates a lot of people, and prison conditions are a concern, and if courts rule that the state has to provide better accommodations, they can have to build or refit at great expense new or larger prisons, or both new and larger prisons. Now we come to our fourth topic in intergovernmental relations, and that is devolution. And discussions about devolution. Remember, devolution means handing power from the national government back to state and local governments, or not necessarily back to, but devolving authority from the central government out to state and local governments. And throughout much of the 20th century, there was a pretty clear partisan pattern to this. Democrats were supportive of a more powerful federal government, so one where more of the control is in the central government's hands, whereas the GOP, or the Republican Party, was associated with states' rights, so with more authority, more being done by the states rather than the federal government. There's a shift in this during the Reagan administration. In the 1980s, devolution was proposed as a way of saving money for the federal government. There was little interest in this from really anyone at any level of government. Remember, state and local governments love block grants. They lobby for block grant money. So there was little interest in having the federal government be less involved in what the states are doing. What devolution does also mean is that the states will be responsible for more things on their own. So you have more authority as a state, but you're also receiving less funding from the government. In the end, though, despite little interest in actual devolution, there was de facto devolution, kind of just in practical terms, devolution as a result of domestic budget cuts resulting in less grant money for the states. The Reagan administration was very much focused on the Cold War and arms race with the Soviet Union and trying to spin the Soviet Union into the ground, which you probably remember, I hope, from your U.S. history class last year. Then, in 1994, we have the Republican Revolution. And this refers to Congress for the first time in 40 years having control of Congress. That means both houses, the House of Representatives and the Senate. And part of what the Republicans wanted was devolution. One example of this that kind of everybody could see was state control over speed limits being handed over. This had been something that was done federally. For example, during the Carter administration, when oil was very expensive and energy was very expensive, and there was a big push to figure out how to reduce America's energy consumption, a nationwide 55-mile-an-hour speed limit was imposed on interstate highways, which brought a lot of resentment. There was even a song by Sammy Hagar called "I Can't Drive 55," and so people were thinking about this as federal control that they didn't like, and so one of the things Republicans did with their control of Congress is release control of speed limits back to the states. And so you see a variety of speed limits. Missouri goes to 70, Iowa hangs back at 65 for a very long time. Montana briefly goes to a no speed limits policy where the only standard is to drive at a reasonable speed. Now, this kind of has relatively short lifespan. In the 2000s, with the George W. Bush administration, and policies like No Child Left Behind, we see growing bipartisan support for federal power. And so that's kind of where we still are in the 2000s. We can find examples that go in different ways. For example, the recent debates over abortion policy after the Supreme Court overturned Roe versus Wade, that has gone back to the states. And in a lot of ways, that is what the Republicans have wanted, is to send that back to the states, where the thinking is they can find supportive voters and supportive legislatures to pass the kind of abortion policies that Republicans prefer. But that would just be one example. The general trend we see is towards a more muscular and active and more powerful federal government. I guess we should leave with a better summary of that. The future of devolution looks really uncertain. I know that's not much of a conclusion to that, but that's kind of where we are. And similar to the status of the 10th Amendment in light of contradictory Supreme Court rulings that we've previously discussed. And now we're going to shift to another topic, and we're going to be focusing on the states themselves. And there are going to be three topics within this area of our look at federalism. The first is becoming a state. The second is policy diversity. And the third is interstate relations. I feel like I'm rattling off categories in Jeopardy. First, becoming a state. The only states that were part of the deal at the beginning were the original 13 states. Every other territory that has become one of the 50 states has had to go through the process of acquiring statehood. And Congress has the power to admit states. Of course, those acts are subject to presidential approval, but Congress has the power to begin the admission process and run everything else. So our focus is going to be on Congress. There are some limits on how Congress can admit new states. No state may be created by taking any territory from an existing state unless that state gives consent, and that has happened. And this is because the federal, let me back up there. In terms of this has happened. So, for example, just to make this clearer, Kentucky here, right, not highlighted in orange, unfortunately, for this part of the discussion, had been part of Virginia. And Virginia consented to allow Kentucky to be formed as a separate state. And also, Maine becomes a state after having been carved off from Vermont. But this can only be done, again, with the consent of the states, because the federal government is constitutionally required to respect the territorial integrity of the states. Another requirement is new states must be admitted on an equal footing with the old. So there can be no privileges for being one of the original 13 as opposed to the other 37 states. In terms of the steps have kind of been different at different times. The first large example we have of new states being created was out of the Northwest Territory, and there Congress had said that territories had to have 60,000 people, but that was kind of on a case-by-case basis. What happens in general terms is a territory requests that Congress admit it to the Union, at which point Congress, if it agrees, passes an enabling act. This enables the territory to draft its own constitution. The Constitution requires, the U.S. Constitution requires, just to be clear, that any state's constitution must be a republican form of government, meaning it must be a representative democracy. Once a constitution is drafted, under the authority of the Enabling Act, there is a territorial convention where all eligible voters will vote whether to approve or reject the new constitution for their future state. If it is approved, and Congress accepts that Constitution, then Congress passes an act of admission. So they pass legislation admitting the state to the Union, and then if the President agrees, the President signs on, and that state is admitted to the Union. Because we do have a federal system with 50 states that have governments that do a lot of things for themselves, we have a lot of policy diversity. And this is a double-edged sword in the sense that there are some quite good things about it. You can live in a state whose policies you agree with, and this is what has happened with perhaps a lot of people leaving California and relocating to Texas based on politics, or people moving to Florida based on politics. They want to live in a place where the policies and the government line up more with what they want. And so as a result of this, we have this saying that the states are 50 laboratories of democracy, where they can come up with new policies and test them out. In a unitary state, without devolved powers to regional or local governments, it's a lot harder for there to be policy innovation because everything comes from the top down. In our system, a state that has a good idea can innovate and adopt a new policy. Other states can see how it plays out and either pick up that policy or reject it. As an example of policy innovation from earlier in this course, we saw what was happening in Portland after Oregon decriminalized even hard drugs, and other states have been able to look at the results of that policy innovation and decide whether they want to adopt it or pick it up. And so far, what we've seen is the results. It has not been a policy innovation that has been appealing to a lot of other states, and as we saw, even Oregon is not certain to stick with that policy innovation. So, of course, that would be the example for you to include in your notes. Another example we've just talked about in terms of policy innovation, once speed limits were handed back to the states, Montana did relatively briefly have a no speed limit policy for some of its highways. That ran into problems, and they were able to reverse it, and other states were able to see how that had played out, and it was not a policy that spread. On the downside of this, if you are unable to relocate to a state whose policies support, you may be stuck in a state whose policies you oppose, right, and whose policies might harm you. If, for example, you live in a state that has very lax environmental protections, and you happen to be someone with low income living near a refinery that might be causing asthma in your children or other health problems, you may not have the means to move to a state where there would be stricter limits on emissions from industry that might be better for the health of your family. And in some cases, especially if you are a child, you have no say in those state policies. Your parents do, right, but you don't. So another example, and I know all of this will be controversial, whether we're talking about environmental protections or, of course, this next one, the current abortion policy debate, where depending on who you are, you either see a state that has pro-choice policies as harmful to unborn babies, or if you live in a state that has strict abortion restrictions, you may see it as a policy that endangers the health of a mother in the case of some life-threatening complication, but where state policy is strictly opposed to abortion and doctors may be afraid to provide medical help that could result in the death of the fetus and accusations that those doctors or surgeons have performed an illegal abortion. And so that's just an example of how you might oppose a policy and see it as harmful to you. Education funding would be another example. Education, most of it is consumed for most of a person's life before you are able to vote, and so you have no say in the educational policies, particularly educational funding, okay, that is going to be important to you in your early years of life. Let's go back. All right, so in terms of different abortion policies, we have this first map shows the current status of things as of the end of October of this year, of 2024, where we've seen a spread of bans. Now, of course, that was October. Missouri voters decided to provide legal protections for abortion, so Missouri will change on that map. And then in terms of educational funding, I mean, there's very wide disparities across the United States. Missouri, $14.7 thousand spending per student. In states like Oregon, it's over $20,000. And New York, over $30,000. Now, some of this, I don't want you to get the sense that you are being horribly deprived. You might be being deprived relative to the spending on students in other states, but some of this might be that there are strong teacher organizations, labor unions, that have been able to acquire very high pay for teachers. And so that doesn't necessarily mean that all that money is getting to students. It may mean that you get better teachers, which would be a benefit to students, but in some ways these numbers don't tell the full story. Yeah, but it does give you a sense of the differences. Okay? And of course, as children, you don't get to vote on the policies for educational spending in your state. All right, the third topic here is interstate relations. Remember, one of the problems under the Articles of Confederation prior to our current Constitution was a lot of conflict, especially economic conflict between the states. Because of the Constitution, interstate relations are much less conflictual, less fractious than they had been. And that's because, there's a powerful national government to regulate trade and prevent those trade disputes. Also relevant here is the full faith and credit clause, bold and underlined because it is important as a key term. And this clause says that states must respect the judgments of each other's court systems, the records of other states. So for example, some of this would be your identification. Your driver's license is accepted as a record of who you are and what you are allowed to do in your state, and it's accepted in all other states, and they have to. This also, of course, includes marriages. A marriage in one state is recognized as a marriage in other states. And this has not always been the case, but as Supreme Court rulings have come out, there's been more acceptance. Loving versus Virginia, a case you should know about from 1967, was a case about interracial marriage. And after that, states were not able to refuse to recognize or even to treat as illegal and punishable interracial marriages. In 2015, Obergefell versus Hodges, the Supreme Court ruled that states cannot refuse to recognize same-sex marriages. Okay, so essentially, even if a state had a law on the books that said they don't recognize or don't allow same-sex marriages, they have to recognize those same-sex marriages through the full faith and credit clause, which is the shift between these two political cartoons, right? Till death or crossing the Pennsylvania state line do you part. Right? And here, the Supreme Court, of course, changing that with Obergefell versus Hodges. And as I said, identity. So that would be driver's licenses, for example, birth certificates being very important as a way of proving who you are. They also have to respect each other's laws. Now, there are limits for this. These issues of respecting are in matters that are civil and not matters of criminal law. Divorce is still can be a touchy subject in relations between the states. If a state grants a divorce to a couple that claim to be residents of a state, another state may refuse to recognize that divorce if a state court decides that they were not bona fide residents of the state that granted the divorce. Some of this issue could be seen early in Nevada. Had a policy that allowed couples to live there, I think, for 6 weeks, and after 6 weeks of residence, you could be granted a divorce. And in the case of Williams versus North Carolina, what is decided is that if a couple is only going to a state to be residents there long enough to obtain a divorce, and they're not residents of that state with the intent of remaining residents of that state, they are not bona fide residences or bona fide residents, and their divorce is not valid and does not have to be recognized by other states. Other elements of interstate relations, some of these we've talked about before. Extradition. In most cases, states have to extradite wanted people accused of crimes that have maybe fled to another state. And we'll talk about some limits to that. There's also the Privileges and Immunities Clause. What this means is states cannot grant privileges to their own residents over people who would be new residents. So you can't deny residency to someone who had been a resident of another state and moves to your state. And you cannot have any unreasonable differences in treatment for long-term residents versus short-term residents. There are some exceptions. For example, if you want to be a candidate for public office, it is acceptable to have residency requirements for that purpose. I mean, and it makes sense. You want people who are running for office in a state to have lived there long enough to have some skin in the game, to have a stake in the future of that state and its policies, and also to know the place that they are trying to represent as an elected official. Also, being licensed. Here I don't mean driver's license, professional licenses like being a physician or an attorney. And there can be residency requirements for that. You might have to be there for a certain period of time before you can become licensed in that state. And of course, some of you will already know this, maybe from vacations or hunting trips. States can give differential treatment to their own residents versus visitors for the purpose of hunting and fishing licenses. Hunting licenses are always less expensive for residents than non-residents, and that distinction is always made through whatever organization you would be dealing with. In the state of Missouri, it would be the Missouri Department of Conservation. If you go to Minnesota, and I've done this in the past, to buy a fishing license, I have to pay a higher price to the Minnesota Department of Natural Resources because I am not a resident of the state of Minnesota. Right? And fish and game are considered to be the common property of the people of that particular state. And that's the reason for the differential treatment. Another exception that some of you are probably already contemplating is tuition. Tuition can be different for in-state and out-of-state students. One major reason for that is students who have grown up in a state have had parents or guardians living in that state paying state sales taxes, property taxes that have supported the state and supported that institution. If you're just coming to that state for school, you've not contributed to that pot of money, and so you will contribute to that pot of money through higher tuition bills. There are also interstate compacts. Now, one thing to keep in mind, states under the Constitution clearly are not allowed to form alliances with each other, and the national government is now strong enough to prevent that. But if Congress approves, states can form what are called compacts. And those may be compacts to deal with things, as it's shown in this map, with water resources, One of the most famous is the Lower Colorado River Compact, where Nevada, California, Arizona, and Utah have to negotiate over water rights and drawing rights from the Colorado River. Just some final thoughts to kind of summarize this, because we've talked about a lot at this point. And so we'll just kind of think about this as the different powers. And some of these we've talked about, and some of these we haven't talked about, or at least maybe not as directly as we're going to do here. So for the powers of the federal government, one that we really haven't talked about to this point are inherent powers. And these are powers of our federal government because they're powers that all states, and by states here I mean countries, have and exercise through their central governments. So control over immigration policy. And we see that currently playing out as some states have tried to take more control over immigration policy and have run up against the authority of the federal government. Recognition. Here I mean the authority to recognize other countries. Famously, the United States shifted its recognition of China from the Republic of China, or Taiwan, to the People's Republic of China, or mainland China. And so as a country, we recognize the People's Republic of China as the China, and we do not actually recognize Taiwan as its own independent country. And that's just one example. Most of the time, recognition of states is not such a controversial thing. And states, in order to preserve themselves, have the inherent power to suppress rebellions. Then there are delegated powers, and we have talked a bit about this, but I want to make it very clear and to the point here. Okay. Delegated powers are powers that are given to the federal government constitutionally. That's social contract language. And the people are delegating powers to the federal government. There are two types within that. The express powers, and here we have talked about these, or enumerated powers, the ones that are explicitly or expressly stated in the Constitution. Then there are those implied powers, especially from the necessary and proper clause, but also over time, the implied powers that can be linked to commerce power, though I generally encourage you to keep those separate in your mind. Implied powers would be the ones linked to necessary and proper clause. And commerce powers, you should think of most of the time as just commerce powers. And then there are exclusive powers, and these are powers that only the federal government has. And some of these might be exclusive and delegated powers. For example, the federal government only has the power to declare war and make treaties. This is a power delegated to it by the Constitution, but it is also an exclusive power of the federal government. And then there are concurrent powers. These are powers that both the federal government and the state governments share. And these would be things like powers dealing with education, or policing, or building and maintaining roads. Powers that we've kind of already talked about as we've looked at the development of federalism in the United States. And then finally, we have the reserved powers. And those are the powers that under the 10th Amendment the states have retained. But remember, because of contradictory Supreme Court rulings, just the extent and nature of these reserved powers remains uncertain. And that concludes our look at federalism. All right, I know a lot of this has not been fun. Talking about grants is not exciting, but these are important things that we need to learn, and this certainly falls into the category of last but not least, make sure you understand these different types of powers.